The judicial system of the United States, federal and in most states, is not worth a dime. More than 90% of the federal and state judges are powermongers and power freaks. More than 60% are outright dishonorable, biased, and have no sense what justice is, and in total they are running a mockery of the judicial system of the good USA. They are dishonest in performing their jobs to different degrees. They have no integrity, thus they deserve no respect. They are making the judicial branch one of the most oppressive systems in the world. Judges are taking advantage of the respect of the majority of the citizens to the laws and running a mockery. I shall expose to you the honest and hard-working citizen and taxpayer of this good country of ours in a series along with the solid proof in a simple way, as it can be demonstrated. Number 1 of this series. An actual case in federal district court. You will see on the screen what I asked the court to do in the prayers for relief. After that you will see a pertinent part of an order describing what I asked the court to do. Please notice that a magistrate judge and a judge fraudulently misrepresented what I asked the court to do. Said judges perverted what I asked the court to do and built their decision on their perversion and fraudulent misrepresentations. You will see my motion to vacate said order. Moreover, I filed an appeal to said order within the time allowed by law, only to be faced with 3 corrupt and dishonest judges in the Ninth Circuit Court. The normal procedure is, a notice of appeal, then a brief is filed, and based on the issues raised in such brief, then the Circuit Court will make its decision based on law alone. Period. Prayers for relief. Wherefore, plaintiff requests a judgment, as follows. 1. Declare C.C.P. 391 through 391.7 unconstitutional, as they violate the 1st, 5th, 14th and 7th Amendments of the U.S. Constitution and 42 U.S. 1983. 2. That this court enter a preliminary and permanent injunction enjoining the enforcement and application of any CCP 391 through 391.7. 3. Declare CC 3333.2 micra unconstitutional, unless the $250,000 is adjusted annually and perpetually beginning in 1976 based on retail price index RP, and if that index is not available at any given year, then it must be adjusted based on consumer price index P, and if the latter isn't available, then based on a similar index or indices. 4. Costs of suit, attorney fees, wherever applicable. 5. All other relief that may be just or plaintiff may be entitled to. Dated, July 20, 2011. To the extent that plaintiff is, directly or implicitly, asking this court to engage in an independent review of the Superior Court order to determine its validity, such review would be barred under the Rooker-Feldman Doctrine. ExxonMobil Corporation v. Saudi Basic Indus, 544 U.S. 280, 284 2005, District of Columbia Court of Appeals v. Feldman, 460 U.S. 462, 482 1983, Rooker v. Fidelit White Trust Co., 263 U.S. 413 415 16 1923. This doctrine provides that, as courts of original jurisdiction, federal district courts have no authority to review final determinations by state courts. Manufactured Home Communities, Incorporated v. City of San Jose, 420 F. 3rd 1022, 1029 9th Circle. 2005. In ExxonMobil, the Supreme Court clarified that the Rooker-Feldman Doctrine bars federal jurisdiction when a losing party in state court has filed a suit in federal court after state proceedings have ended, complains of an injury caused by the state court judgment, and seeks review and rejection of the state court judgment. ExxonMobil, 544 U.S. at 29192. Plaintiff's motion to vacate the court's order. 1. Plaintiff is shocked and appalled at the perversion by judicial officers who are entrusted and sworn to execute their office honestly. The attachment to said order is full of perversions of the relief sought in the complaint. The relief sought in the complaint is under the title Prayers for Relief on page 13 of the complaint. Nowhere plaintiff asked for an independent review of a superior court order. Period. As a matter of fact, no state superior court made an order in which plaintiff was found to be vexatious or made an order for pre-filing period. No such order exists period. A student in middle school can understand that, or any person with IQ over 80 should be able to comprehend said relief. To pervert and misrepresent said relief is a total violation of the canons of judicial conduct and the ethical and moral conduct of federal judges. Since said perversions and misrepresentations are intentional, then it constitutes fraud. To build and base legal reasons and conclusion on perversions is very shameful. The reason I included copies of What Happened by P.J. Bourne is to show violation of my rights by a corrupt judge using a clear and obvious unconstitutional statutes, even violating a published opinion. But the Westwood Park Association 62 Cal.App. 4th at P 1217. Therefore the Exxon, D.C. Court of Appeal, Rooker and manufactured home cases cited in said attachment have nothing to do with the relief sought by plaintiff period. Plaintiff warned this court to be objective and to base its decision on pure constitutional grounds, not on dirty political views or corruption, since the subject matter has its corrupt supporters. 2. The Wolf v. George case did not address the 65 grounds and reasons clearly stated in this complaint. Addressing few constitutional grounds by the Ninth Circuit does not bar challenges on other grounds and reasons. Any court cannot address what is not before it. That is why more than one case can be cited on a single issue. Here you have many issues, reasons and grounds raised, the majority of which were never before any court. I challenge you to produce a case or cases in which each single ground and reason of the 65 presented in this complaint was dealt with before in a district court or appellate or U.S. Supreme Court. Referencing said statutes in a local rule is patently frivolous, when the U.S. Congress refused to give federal district courts any analogous law period. It just shows more corruption. By the way, I am the first person ever, to my knowledge, who used the word patently in legal papers, years ago. 3. An application to proceed in forma pauperis should and must be based solely on the financial condition of the applicant but not on the merits of the complaint period. A paying plaintiff is treated entirely different, and that constitutes an equal treatment and discrimination. The bigger question is, why some sick individuals in this country pick on poor people in many aspects. I treat people in an equal manner regardless of economical status. I talk to all people, the most educated and the least, the rich and poor, with the respect they deserve. Remember, that respect is earned. My Lord lived all his life as a poor person, despite the fact that he created and owned everything, and so should I live by his example. Remember, everyone is but dust and ashes. Nobody ever was able to take material things, when they die, or ever will. 4. A judge should be neutral and impartial. Each side of a litigation presents his position, then and only then a judge decides what is presented purely on law period. In this case the judges became, right away, my adversaries and enemies, perverted the relief I am seeking and built their decision on their own perversion and their own total fraudulent misrepresentations. Wherefore, I request an order based on my financial condition period. Dated, August 6, 2011.